Hi, students. I'm back again. This is on Unit 5, which corresponds to Chapter 5 of your book, if you're keeping track of that. It's week 9 in the class. It's on surveillance. It's the halfway point of this course. It's good news. And following this unit, you'll be taking your second test, which is on Chapters 3, 4, and 5. Chapters 3, 4, and 5 are all concerned with the Fourth Amendment. After this unit, we'll be moving on to other amendments to the Constitution, other protections in the Bill of Rights. So anyway, so we're talking about police surveillance here. So the question I have for you is, do police officers use surveillance techniques to further their investigations? Well, sure they do. They use all kinds of surveillance. There's just your typical non-technical type of surveillance, which is just your observation as a police officer. You're on patrol. Uh, you're looking around. You're observing people and looking at their circumstances to see if there's any criminal activity, and if there is, you're going to take the appropriate action then. But there's also kind of a lot of technology type of surveillance. There's electronic tracking device that can be installed on a vehicle, like in the Jones case. There's video surveillance, thermal imaging, which is a infrared device that picks up energy. Firefighters use that now to look through smoke to determine where the fire is, where victims are inside. Um, there's pen and trap devices, wiretaps, drones. I know that our sheriff's office in Madera has I wouldn't say a drone unit, but they have a number of different drones. In fact, they launch the drones when they serve search warrants now. They use them for search and rescue. They can do surveillance with them if they suspect marijuana being grown. They can launch them and, surveil from the drone. There's a Google Street View. They use planes for surveillance, helicopters. There's pull cameras. They can put a camera on a telephone pole. It's a fixed location, and they can connect that to a computer, and they can watch through their computer. They can manipulate the camera through their computer, zoom in, zoom out, turn it, and watch a particular area. There's a device called a Stingray. It's a portable device, like a small suitcase, but it tricks your cell phone into thinking it's a cell tower, and it will identify your number. So if they're looking for a particular person, terrorist, and they believe that person's in a certain area, then they can set that up, and they can use that to track you down. Um, so there's actually all types of surveillance equipment that are used by law enforcement. So what's the law that governs this area that we call police surveillance? Well, we're talking about the Fourth Amendment. That's the foundation of surveillance law. And going back to colonial times, remember the colonials were concerned with their privacy, and they were concerned about physical intrusions into their protected areas, their physical intrusion on their person, their property, their homes, and so because of those intrusions and violation of their privacy, they wanted to protect themselves from this government intrusion. So that led to the um, ratification of the Fourth Amendment to the Constitution. Now, you've already had the law that applies. I've already talked to you about it. And those are the cases of Olmstead, Katz, and Jones. So remember, Olmstead was the case involving the wiretap on a telephone line across the street from the house, and the court said, well, that there was no physical intrusion because a wiretap was across the street on a telephone pole. There was no physical intrusion into this home. Therefore, there's no violation of the Fourth Amendment. Remember then in Katz was the recorder on top of the telephone booth case, and the court said, well, yes, there was no physical intrusion, but we're defining a search as a violation of a person's reasonable expectation of privacy. And since this person has had a reasonable expectation of privacy that is in his conversation, in other words, his conversation would be private, and the officers violated that expectation of privacy, then they needed a search warrant. And since they did not have a search warrant, the evidence was suppressed. And then along came Jones, which was the tracking device on a car case, and the court said, well, this was simply a physical intrusion. But not only that, they also said, you have to read Katz and Jones together. So a search occurs either when there's a physical intrusion or there's a violation of someone's reasonable expectation of privacy. So that's the law. That is the law that governs police surveillance. Now we have to take that law and apply that law. So when we look at when police officers look at things that are exposed to their view, to their senses, so to speak, and typically it's more to their eyesight. In other words, they make an observation. They're out in the public. Then you don't have an issue with the Fourth Amendment, honestly. So anything that's in public view, they say, is fair game, and a search warrant is not required. That not only applies to what they can see with their eyes, but it also applies to use of any devices that enable the police to observe more effectively matters that are in open view. So what could they use to help them see better? Well, they could use at night a flashlight. They could use things like binoculars, telescopes, cameras, even video cameras in aircraft. If things are in open view, then it's fair game. So when I was a police officer, and most of the officers that I worked with, we all carried binoculars. So if we wanted to watch people, and of course we're in a patrol car in uniform, I mean, if you get too close, they're not going to do, they're going to be careful. So, we could sit a further, out a ways, and we could just watch them through binoculars. Sometimes we'd even park our car and get out on foot with our binoculars and go to a place where they couldn't see us and watch them. And from that position, we could either take direct action, or we could direct other officers in as you continue to watch them. So, and that's perfectly lawful. What about if the officers are looking for something that is hidden from view, or they have to commit a physical intrusion? Well, the rule. That's the definition of a search. And if they're searching, what does that require? It requires a search warrant, or it requires an exception to the warrant. So what are examples of a physical intrusion? Well, the obvious one was the Jones case, where they actually did what? They attached a tracking device on a car. So that was a physical intrusion that required a search warrant or exception. Another physical intrusion is a case, it's called Jardines, and in this particular case, the officers had information that the person inside a home was cultivating marijuana. That's all they had. They didn't have enough to write a search warrant. It was, a tip. Wasn't verified or corroborated, so it was a confidential informant, but it wasn't sufficient to get a warrant. So the officers decided to take a a dog, a police dog, and they entered onto the property, walked up the front sidewalk to the porch, and the dog, when he got up onto the porch, alerted to the presence of contraband inside the house. And based on that alert, the officers wrote a search warrant, served the search warrant, found the contraband or the narcotics inside the home. The person was charged. The person made a motion to suppress the evidence. So it ended up all the way in the U.S. Supreme Court. What did the U.S. Supreme Court say about what these officers did? Did the officers, first of all, have a right to enter this person's property? Do they have a right to come onto your property with a police dog? What do you think? Now, I would venture to say that you allow the FedEx person, Amazon driver to deliver packages on. You allow the postman onto your property to deliver mail. You allow the Girl Scouts to come onto your property to sell Girl Scout cookies. You allow Jehovah Witnesses to come onto your property to evangelize. So, there is like an implied consent that you have given to certain people to come onto your property for legitimate purposes, right? But the court kind of set this aside and said, you know what? Yes, people do generally allow those types of legitimate visitors to come onto your property. That's implied consent by you, but there is no actual consent or implied consent for a police officer to bring a dog onto your property for the purpose of sniffing the front porch and the door to see if it will determine if there's drugs inside. So that's one thing. But the other thing, I think it was Scalia that wrote the opinion, and it was Scalia that decided Jones. He said, you know what, this case is very simple. This is a case about simply a physical intrusion into a protected area. And when you physically intrude into a protected area, then you need a search warrant or an exception. And since they did not have a search warrant, there was no implied consent to allow an officer onto the property. They didn't have a search warrant. The motion to suppress was granted. So that's public view. That's matters not in public view. So remember, activities that are hidden from public view are expected to be private and require a search warrant or a recognized exception. This also includes the use of technology. So if you're using technology, any kind of technology, to obtain something that is hidden from view or requires some sort of physical intrusion, then you're going to need a warrant or an exception to the warrant. Um, what about your home? I want to talk about your home for a few minutes. Your home, actually, if you go back to colonial times, was considered to be your castle, and that has the most protection other than your person under the Fourth Amendment. So the home not only includes your home, the building itself, but it also includes the area immediately around the home used for living purposes. It's the living area around the house for living related activities. And this particular area around the house is called the curtilage. And so the Fourth Amendment not only protects your home, but it also protects the area within this curtilage, this area immediately around the home that's used for living activities. Now, how do you know what the curtilage is? Well, it's pretty easy. If you just drove down the street, you know the area around the house. It might be the front yard. You can tell the side yards and backyards. It's fenced in. It's pretty much area set aside around the house where you can tell it's used by the homeowners, tenants for living activities. What about homes that are on ranches and farms and that are situated on larger parcels of property. So you still have the home that's protected under the Fourth Amendment. You still have the curtilage and the area immediately around the home that's used for living purposes and living activities that's protected by the Fourth Amendment. In other words, you have to get a search warrant. What about the area that's beyond the curtilage, though? It's still owned by this homeowner, but it's outside of the curtilage. There was a case, it was, I think it's called Payton. No, I'm sorry, it was Dunn. Dunn was a case where this house was on a ranch or small farm. So you had the house, you had the curtilage, that area around the house, and then you had a larger parcel of property that was like a small ranchette farm, and it was cross fenced for cattle and animals, and there was a barn outside of the curtilage. So the officers had information that this person possessed contraband inside the barn. The officers went to the property, went onto the property. They were outside the curtilage, though, outside of the curtilage. They trespassed onto this property. In other words, they did not have permission. They looked into the barn. They didn't go into the barn. They looked from outside of the barn into the barn. They saw the contraband. They left, wrote a warrant, came back and served it and seized it and arrested this person. He was charged, made a motion to suppress. This went up to the U.S. Supreme Court. What did the court say about this area outside of the curtilage? The area outside of the curtilage has less protection. It didn't require a search warrant. The officers, although there was a technical trespass, the court said that was permissible for them to enter onto the land and make their observation of what was inside of the barn while standing outside of the barn. So the search warrant was upheld. The motion to suppress was denied. So when you get into that area outside of the curtilage, it's called an open field, the open field doctrine. So just remember that. The house is protected, has heightened protection. The area within that curtilage, the living area around the house has the same protection as the house. So if the officers are going to breach that, physically intrude in that area, they're going to need a warrant or they're going to need an exception. The area outside of the curtilage would be considered an open field. The open field doctrine would allow the officers to go onto that property without a warrant, make an observation, then return with a warrant. So, so that covers matters that are in public view, matters that are hidden from view, matters where there's a physical intrusion. We've discussed the home. I just might mention to you that if under this area, if there's any information that a person discloses to a third party, so if I'm a criminal and I voluntarily disclose, make a confession or admission to somebody or make a drug deal, with a third party, and that third party's an informant, that's not protected. That third party can basically inform on me, and that's not protected. So, like, let's say they arrest me and they put me in a cell, and the cops are smart and they actually put another officer there, and the officer doesn't ask questions. The officer is just there to listen. That's not going to be a problem. And if I happen to disclose what I did to that officer can then be called as a witness. There is no protection under the Fourth Amendment for that. Also, let's say if I'm arrested, I'm in the cell, they put an undercover officer in there to listen, but also not only is he listening, he's wearing a recording device. So he's recording what I'm saying. It's the same principle because the recording device is only capturing what he could hear anyway. So that is perfectly lawful as well. I want to just wrap up this chapter on the Wiretap Act. So after Katz, that was the phone booth case with the with the recorder on top. Congress enacted the Wiretap Act. It's in the U.S. Code, 18 U.S. Code. So the Wiretap Act. So the state of California also has its own Wiretap Act, and in order to comply with the Wiretap Act, there has to be a warrant issued, and I'll talk about that in just a moment. But really, the way to think about the Wiretap Act and this warrant is that it requires what I would refer to as a super search warrant. Now, you read the warrant, the sample warrant for the course, so it's similar to that, but it has more requirements than that. So that's why I call it a super search warrant. But it would be it requires probable cause. It's going to be an order issued by a judge to seize evidence of conversations, criminal conversations, but it has more requirements that have to be met by law enforcement and able to procure this type of warrant. So that's what I want to talk to you for a few minutes before I end this particular lecture. So the Wiretap Act, as I said, was enacted in response to the Katz case, and it prohibits the government from intercepting a protected communication with a device. So it has to be right there. It has to be protected communication. It has to be with a device. Not your ear, it has to be a device, and it has to be a protected communication. So it prohibits officers from doing that unless they have either a wiretap order or one of the parties consents. And so the Wiretap Act is when it's a protected communication. What is a protected communication? Well, the communication can be a wire communication. It can be like a telephone. It could be oral, like me speaking to somebody, or it could be electronic. Electronic, it could be a computer message, for example, that would be electronic. And the other requirement, not only is it for protected communication, law enforcement wants access to the contents of the communication. So, for example, not just the phone number that the person's using, but actually what is being communicated, what is being said. And then third, and I already mentioned this, there has to be a device used. So if you have a protected communication, the officers want access to the message or the communication, and they're using a device, the Wiretap Act is triggered and they need to obtain an order. So generally, it's the same procedure as obtaining a search warrant, like I mentioned, but there's a couple modifications. First of all, it's limited to the most serious crimes in the Wiretap Act. California is the same way. The crimes are listed. You don't have to know them, but just know it's the most serious crimes. So you can think murder, kidnapping, probably sex crimes, things of that nature, the most serious crimes. Secondly, it has to be approved by a high-ranking DOJ official. So generally in a search warrant, the officer would write the warrant, the officer would take it right to a judge. This requires an intermediate step, and that is the officer would write it, then have to take it to a prosecutor, a high-ranking prosecutor, and that prosecutor would have to approve it. Sorry about that. The prosecutor would have to approve that. Third, they have to show that traditional investigation has been tried and failed or is too dangerous. So, for example, let's say the officers are investigating a criminal street gang. It could be Hell's Angels. It could be, a Mexican mafia. It could be Serranos, Norteños. It could be any criminal street gang, and it's just too dangerous to use traditional techniques, and they would have to show that either they've tried the traditional techniques to investigate this group, or it's just too dangerous, and they have to show that in their affidavit. Of course, they have to show probable cause. So they have to show probable cause that these folks are committing a crime. They're using this device to use or they're communicating their criminal activity, and the officers are able to seize evidence of this communication through the wiretap act, or wiretap order. So they have to have probable cause. The wiretap is actually limited to 30 days or attainment, but may be renewed with a fresh application. So there's a limitation on how long you can have a wiretap up. Also, there's a requirement of minimization. All that simply means is that the only communication that the officers can seize involve criminal activity. They can't seize a communication that is not criminal in nature because it's not evidence of any crime. They don't have a right to seize it. So how would that work? So you have a wiretap order. There's a wiretap set up. So when I was in the FBI, I sat on some wiretaps, and so they scheduled the agents in. There was a room in the building that was just for wiretaps, and I was assigned a shift, and I sat at a console, and I put on earphones. There's a recording device in front of me, and every time there was a call either coming or going from this particular number, it would set off an alarm, audible, and I would turn on the recorder. And when I turned on the recorder, I would listen to the conversation. If the conversation was criminal in nature, I would continue to record it. However, if I determined that it was not criminal in nature, technically I was not allowed to seize it, so I would turn the recorder off. So I would turn it on and off. So I would leave it on when they were talking about the crime, and I'd turn it off when they were not talking about the crime. That's called minimization. Also, there's limits on disclosure to further the investigation or national defense. So how could they disclose this to further investigation? Well, one cool way is, so they have a wiretap act as an example up on a guy that is a drug dealer, and they're listening to a conversation, and the guy is talking about bringing drugs from one area to another area. Then they could have a ground team out there, and they could pass that information on to a ground team, and that ground team can interdict that shipment. So that could be done as they're listening to the wiretap. Also, they can intercept. They can actually intercept without a wiretap order in an emergency, but as soon as they can, they have to apply for a wiretap order. If it's denied, then they would have to shut it down. And then also they can direct third parties to help assist in the execution of the order. So let's say if they had to put a wiretap in a restaurant or in a car or in another business, and they needed help to do that, locksmith or the landlord or the super or somebody like that, then they could get an order for that person to assist. It's dangerous to do that because you don't know if the person will disclose, but they can get that kind of order. So what's not regulated by the Wiretap Act? If you're listening with your ear, because it's not a device, it's not regulated. If the target is engaged in an oral communication, there's no reasonable expectation of privacy. So if people are talking to each other and they're talking loud enough and it could be overheard by other people, then there's no expectation of privacy, then the Wiretap Act would not apply. But if people are talking to each other and they're creating an expectation of privacy, so for example, they're in a restaurant, they're in a back booth and they're holding menus up and they're talking real low, and they're creating a reasonable expectation of privacy, you can't hear that conversation. The only way you could get the conversation is with a bug, then you're going to have to comply with the Wiretap Act. Email, voicemail, text messages are not controlled by the Wiretap Act. and generally, but they are protected. Believe me, there's a Stored Electronic Communication Act. So, and generally, the reason for that is because the officers are not actually trying to intercept those while they're actually being sent. They're going to intercept them after they've reached the server where they're stored. And since they're stored, then this other law will apply to them. And then pen registers and trap and trace devices. Those are devices installed on a phone to identify the numbers that are being called um, from the phone and the numbers that are calling to a particular phone. Those are not, you don't have to comply with the Wiretap Act because you're not seeking the contents of any conversation, contents of the communication. You're just getting a phone number. Why do they want to use those? Well, they take that phone number, they obtain subscriber information. They get the name. They can check the name. They can look at not only the name, the address. They can put up surveillance. They can do records checks, warrants checks. They can do surveillance. They can do a lot of things with just that information alone. Believe me. And then also the other thing is that electronic surveillance to gather foreign intelligence is not regulated by the Wiretap Act. It's regulated by a different act, FISA, Foreign Intelligence Surveillance Act. Actually, if you've been paying attention to the news, there's been FISA abuses by the FBI, high-ranking FBI, and President Trump and President Trump's supporters. There's a big investigation about that by U.S. Attorney. I'm not sure where he's at, but his name is Durham. He's looking into that, and there may be some indictments of some of these FBI agents for doing that. So time will tell. Anyway, sorry for that disturbance, but I'm in my office and people are trying to get a hold of me apparently. So, but that ends this chapter, and you're going to be taking your second test. So take a look at that, chapters 3, 4, and 5. Halfway done, and 9 weeks, 9 to go, and just hang in there, stay safe, and I'll look forward to the next lecture. Thanks.